Hi, this is Tracy. This is this video is in regards to the first and second errors noted in the judgment order. Okay, this is an email dated November 18th, 2024 at 3:17 p.m. This video will cover the first 9 pages, pages 1 through 9 rather, because pages 10 through 16 are covered in video entitled Error Number 3. I wrote 11/18/24 second email, case 2022 CP 3200784 to Supreme Court of South Carolina, Office of Disciplinary Counsel, and Lexington County Courthouse. Judge Spence, 9:41 a.m. email is noted for plaintiff attorney to review documents and provide a response by December 5th, 2024. Please advise the following. 1. What is the status of the judgment order? Is it still available for public display? 2. Is the judgment timeline/clock halted? 3. When will the court provide an answer to the following? June 21, 2024 is not the first time Judge Spence and U.S. Bank National Association met unlawfully without this defendant being present. Neither has the court addressed the 6-day delayed filing of this defendant's motion to move to an inactive roster. Neither has this court addressed the plaintiff's fraudulent notice of home acquisition delivered to the defendant via certified USPS mail August 3rd, 2022. Is this not mail fraud? Here are the 11/15/24 notifications sent regarding the other noted errors in the court's summary judgment order. November 15th, 24, 6:15 a.m. correspondence. Good morning, all. Judge Spence judgment for the plaintiff, U.S. Bank National, is noted. Here are pages 1 and 3. We're going to look at 1, GAL. The defendant had previously filed a motion requesting that a guardian ad litem be appointed for her. A guardian ad litem was not appointed in this case, as the defendant is not under a disability, as would allow for the appointment of a GAL pursuant to the South Carolina Rules of Civil Procedure. And number 2, appointed attorney. The defendant also appeared to argue that since she could not afford or obtain an attorney, then the court should appoint an attorney for her. While the landmark 1963 Supreme Court case Gideon versus Wainwright established that indigent defendants have a right to counsel in criminal cases, the extension of this right to a civil Gideon in civil court cases has never been established. South Carolina has not adopted or established a right to a civil Gideon other than certain family court type cases, etc. So the defendant does not have the legal right to have counsel appointed for her in this case. Again, that is what is written in the judgment order. Continuing, here's my response. I forgive you all. Now, may the real God arise. This is my notice of appeal. Be it known, I never requested an attorney to be provided for me. This appears to be in reference to the defunct attorney office provided by the Supreme Court of the United States, which was later titled a quote-unquote glitch by the said court. I ask again for the erroneous statement regarding the guardian ad litem to be corrected, please. Here again is the filed copy of U.S. Bank's demand that I filed for the guardian ad litem. This document that is within the body of the email is page 9 of 95 of a document that I filed entitled Notice of Home Acquisition. Because this one in the email is not that clear, as you can see here, I am going to switch to the actual document now. So this is the same document that is within the email sent. And I wrote, filed March 4th, 2022, plaintiff U.S. Bank order without merit, demanding defendant submit guardian ad litem application. Violation number 5, targeting/malicious intent. This is the actual summons that was filed with the court by U.S. Bank March 4th of 2022. This is the area that we're going to focus on. And here's the close-up. To minor over 14 years of age and or to minor under 14 years of age, and the person with whom the minor resides, and or to persons under some legal disability. You are further summoned and notified to apply for the appointment of a guardian ad litem within 30 days after the service of the summons and notice upon you. If you fail to do so, application for such appointment will be made by the plaintiff immediately and separately, and such application will be deemed absolute and total in the absence of your application for such an appointment within 30 days after the service of the summons and complaint upon you. Returning to the email. Lastly, Clerk of Courts, please file this and all documents under my name submitted for filing, including but not limited to the documents referenced in this filed response, dated November 11th, 2024, filed November 14th, 2024, below. This is a document I filed. It is entitled Defendant's Response to Judge's Request, Update and Clarification. This is an update to the November 7th, 2024 Defendant's Response to Judge's Request, redacted version below. 1. Please redact/remove the November 7, 2024 defendant's response to judge's request document. Note, the 14-page document is profiled as 28 pages, duplicated, and filed under U.S. Bank National Association with printing obscuring the information. Please file this defendant's electronically submitted documents electronically as is done with U.S. Bank National Association. See plaintiff electronically filed document below. Two, distribution of information received is needed. Permission is requested. Please advise. 3, today is a holiday. Additional time requested. Please advise. Questions. Documentation has already been filed of this defendant's request for congressional review, pending RICO case, and request for removal filed with the Supreme Court of the United States. Such filings were previously acceptable to halt state proceedings. Please specify what exactly is this court looking for. Number 4, please file the defendant's rebuttal to plaintiff's second summary judgment attempt, 15 pages, and the associated appendix, 35 pages, both dated 11/3/24. When will both this defendant's and the plaintiff's proposed orders be filed online? Please advise. 5, clarification. FHA/HUD document is new. The information contained thereon is not. Here is the first page of the previously filed document with identical information. There is a document here that's supposed to be here that for some reason did not print when I printed this. So I would have to get that at a later time. Continuing with the email. (11/15/24) 804 correspondence. Hello again. Clarification. The institution of the Supreme Court of the United States is still honorable and highly revered, as it should be. The glitch defunct attorney office provided at this superior court was an apparent error, as was documented in records submitted to this court, including the following taken from the federal notice of removal still pending in the said honorable courts. Six, 7/2024 NOR is the notice of removal, abbreviated. I'm not going to read it all, but I want to draw your attention to this number 10. This document is from the questions, rather, is from the Supreme Court of the United States. What I'm going to read to you is my response to number 10, which asks, have I paid or will I be paying an attorney any money for services in connection with this case, including the completion of this form? My response: unable to pay and cautious about another derailment attempt as described in writ of certiorari to U.S. District Court of South Carolina. However, I am in need of an attorney. Note, I request attorney referrals, but respectfully decline attorney appointments due to previous derailment experiences. The rest of this I'm not going to go over or review at this time. Continuing with my emailed response. Clerk of Court, please file this and all documents under my name submitted for filing. Thank you for removing the blocks so you can receive my emails. You know who you are. Respectfully, Tracy. Continuing with emails sent. This one is November 15th, 2024, 6:15 a.m. I wrote, here is an unobscured copy of the document taken from the federal notice of removal referenced / noted above. This is a duplicate of the document that I just read from. And again, I'm not going to go in detail over it at this time. I write here, continuing with what I wrote in the email. Thank you in advance, Supreme Court of South Carolina, Office of Disciplinary Counsel, and Lexington County Courthouse for preserving the sacredness of your roles as judicial personnel by rectifying this situation in a lawful and timely manner. Respectfully, Tracy. In this section here, this lets you know, I put note, these are the individuals who received this email, who were included on the email. And this concludes the first two errors that were noted in the judgment order. Number one, the guardian ad litem. The statement was that I submitted a request when facts show I was made to submit a request. It was demanded of me, or U.S. Bank National was going to submit a request for me without merit. And number two, appointing attorney appointment. The judgment order stated that I requested an attorney, but here is documentation that's on file with the Supreme Court of the United States where I request attorney referrals, but decline attorney appointments due to previous derailment experiences. I have requested correction of the errors. However, on November 23rd, 2024, I received a mailed copy of the judgment order, and it is unchanged. Thank you for your time.